Hi, Kate here from the Safeguarding Academy and welcome to this week's 5-minute masterclass. This week we're talking about interim orders and specifically interim care orders. Interim care orders are an order made by the court when a local authority has asked to share parental responsibility because it is worried that a child's welfare is being harmed and a child is at risk of suffering significant harm from his or her carers. An interim order is an order made usually at the outset of proceedings, so right at the beginning, and it's an order which only lasts as long as the court proceedings themselves. It can be as little as 19 weeks, sometimes as long as 30 plus weeks, but it's an interim order, so it's not a permanent order. However, what an interim order does is it is made when a court is satisfied that there's enough evidence to show that a child's at reasonable risk of suffering significant harm. So it's a reasonable risk that a local authority has to prove is the situation. And an interim order will give a local authority, an interim care order that is, will give a local authority parental responsibility. It doesn't take parental responsibility away from parents, but it means the local authority is sharing parental responsibility. And in a lot of ways, it's an overarching parental responsibility. So in effect, it trumps a parent's parental responsibility. So if a parent doesn't like what a local authority is doing, or a parent doesn't like that there are medical appointments to be taken, or there are various assessments that need carrying out, a local authority has that overarching parental responsibility that basically says it's going to happen and this is what's going to go on. A local authority should always work with parents. It should not use this interim order as a stick with which to beat parents around to get them to do what they want them to do. It's very much a two-way street, so parents to cooperate with the local authority and local authority to cooperate with parents. But it's an order that means there can be interventions here which can be quite harsh and can be seen as quite difficult to take by parents. For professionals involved, it means that any information that would be shared with parents needs to be shared with a local authority. A local authority can make decisions around day-to-day care of the child. It will delegate that parental responsibility to a foster carer, so the foster carer can take the child to medical appointments, to dental appointments, can make decisions around various school trips, things like that. It's not the parents that then make that decision, but it should be done together rather than one over the other. That's the best way to do it, is one with the other rather than one over the other. In terms of information, if a school has concerns, yes, it needs to tell the local authority, but you need to share it with parents as well. Equally, if there are medical issues, share it with everybody with parental responsibility. The interim care order itself is, as I say, an interim measure. It's a holding position whilst there are proceedings ongoing. And those involved with the family should encourage parents to work with the local authority as far as is possible. There are very tight timescales involved in court proceedings. The maximum amount of time a court case should take is 26 weeks. So that's half a year. But when you factor in all the other decisions that have to be made, it's usually about 12 weeks. So interim orders are essential to allow a local authority to carry out its duties and to make sure a child's welfare needs are being met. But they should also be seen by those working with the families as not a deferral point to a local authority, but rather, again, a supporting position to encourage parents to work with the local authority for really what is a last-ditch chance to demonstrate that they can meet the needs of their child within the proceedings. Until next week, have a great week.